is open, because I can actually conduct it on that screen.
Oh, really?
Yeah. I found it looking at that, in that direction all the time, just,
Yeah, kind of annoying.
okay, we are broadcasting. Simon Bree. Timothy Williams. I'm not sure if it's DeBenny or DeBean. Can you hear me? Good morning. I had a note on my docket from my secretary indicating that the Breeze versus Breeze matter was going to be renoticed.
That's correct, Your Honor.
All right. Is there another attorney on this matter?
Yes, Mr. Tim Williams was just retained yesterday and requested the adjournment. And of course, as a professional courtesy, I said, okay. We did try to call the court, so I couldn't get a hold of anybody. So I wanted to pop on and hear Mr. Williams right now. I just wanted to make sure we're good.
I had a voicemail. Mr. Williams, this matter is being adjourned for a week at your request.
All right, thank you.
Three
You're welcome.
3 weeks available, Your Honor. I think that's what Mr. Williams requested.
Probably.
Okay.
Just
I'll-
check the entire. Yeah, I'm sure it is.
I will.
On a
I'll tell you
Thursday
that.
morning, I'm sure it's available. All right.
I'll
I didn't want to keep you waiting out there. Have a good day.
Appreciate it. Thank you. Take care.
Okay, Shannon, you can put us on. All right, as soon as we have an audio connection with everyone. Okay, this is a matter of Fagan versus Fagan, and we're here to get a judgment entered. I read the objections. And I see we've got a problem with the school that I'm going to have to address. I'm sorry, Mr. Hilderly for the plaintiff, Ms. Fleming for the defendant, and both of the parties are also present.
Thank you.
So, has there been confirmation to your satisfaction, Mr. Hilderly, that Grass Lake Schools will not allow school of choice enrollment?
No, Your Honor. What I would say is this is an easy solution. They will either take the kids or they won't. I think the order should say exactly what your opinion says. If we then try to enroll them and they won't accept them, then that's fine. But my client has spoken directly with the superintendent, and the superintendent has told him that they will comply with the court's order and enroll the kids. I know Ms. Fleming is saying something different, which is fine. I don't know who she spoke with, but all we have to do is have the order say exactly what your opinion said, and then the school will do what they do. If they say we're not taking school of choice, fine. Well, we understand they'll stay where they are for now, and we'll deal with it next school year. But our information is that they will take them. pursuant to a court order. We would just ask that the court order be consistent with your opinion, and then we'll deal with it from there.
All right, and there was a question as to which custody order I was referring to in my opinion. Just so the record's clear, I was referring to the temporary order. That was my intent. So that leaves then the other objections as to a number of the provisions in the judgment of divorce, Mr. Hilderly, that I did not order on the record.
Yeah, we understand that those were not addressed. I suppose the order can just be silent, or the judgment can be silent on those issues, but I don't know how the court wants to proceed. Seems like the judgment's going to be incomplete if we don't address them in some manner. If Your Honor wants,
let's just go through each of them.
Your Honor,
Obviously, I was mostly focused on custody and parenting time issues. Go ahead, Ms. Fleming.
thank you. I guess before we moved on to these other provisions, I wanted to be clear in the court's ruling as to the school issue. So if Grass Lake will not accept the children as school of choice, is it your order then that they remain in Stockbridge schools? Because my client has spoken with the superintendent's office and they have told her that they are not accepting school of choice regardless of what this court's order says.
So what Mr. Hilderly has suggested is that I simply order as I ruled, and if that problem comes up, that I address it at a future date.
Okay.
Is that correct, Mr. Hilderly?
well, I understand that if they can't go to Grass Lake, it really wouldn't make sense for them to go anywhere else. I don't think for this school year, they might as well stay in Stockbridge. I don't know where else they would go. So I understand that if they can't go to Grass Lake this year, then we'll have to wait till next year to get them enrolled into Grass Lake. We understand that. So no, I'm not suggesting we have to readdress it. I think have the order say they go to Grass Lake. If we can't do it, they just stay at Stockbridge for the rest of this year.
And I assume that's acceptable to you and your client, Ms. Fleming?
Yes.
Okay, so that resolves that issue. Let's go through these objections. Let me get them in front of me. Okay. So where have the parties been doing exchanges?
So at the beginning of Mr. Fagan's parenting time, the parties meet at the police station or the police department in Stockbridge. And at the end of his parenting time, the parties meet at the state police
Yes.
on Cooper Street. So at the beginning of his parenting time, it's more towards my client, and at the end, it's closer to him. And that has been working well.
If that's been working well and is acceptable to both parties, you can include that in the judgment. Okay. Spousal support, I acknowledge I didn't address that, but nobody was seeking spousal support. Based upon that, I'm going to bar spousal support.
Your Honor, and I understand that, but there's a difference. If the court orders it, it's not a waiver by my client. I understand the court has every right to bar it, but that doesn't mean
You
she's
could take-
waiving anything.
I agree. You could take out the waiver language and just include a provision that the court orders that spousal support is forever barred for both parties. Child dependency tax exemption, I did not address.
Your Honor, let me ask Alexis. Alexis, are you okay with including that provision so that there's no misunderstanding that Mr. Fagan would claim Corbin and you would claim Millie?
Yes, the only thing that I was asking is that he doesn't get to claim them until his rearages are paid up by December.
So, Your Honor,
I-
there's often language included in a judgment that whatever the parties agree or the court orders that they can each claim, as long as the person claiming a child does not have an arrearage in child support as of December 31st at the end of the tax year for which they're going to claim the child.
If I were to order something like that, I would expect that the parent who's being otherwise denied that tax deduction that year would get credit on his child support arrearage for whatever the amount of that deduction or exemption is. Is there a way to do that?
That would require somebody to, the accountant, the amount. Do you understand what he's saying, Alexis?
Yeah,
You would have to figure out what you're gaining. I mean, so what's the credit? Is the credit what she's gaining or the credit what he's losing? Because it might be different.
right.
The credit would be what she's gaining, and it would have to be credited towards his child support arrearage, and vice versa.
Your Honor, can I interject?
Of course.
I don't believe, my understanding is that Mr. Fagan is subject to an income withholding order. Am I incorrect in that?
He is.
So I don't believe the arrearage is the result of any non-payment or failure to pay. I think it's one of those situations where he started with an arrearage because of the delay that it takes for the friend of the court to do a calculation, and that it goes retroactive back to when they start their process. So I don't know that we need this provision. He's subject to an income withholding order. It's child support's getting paid. And the arrearage is most likely the result of the retroactive effect of the initial order. I don't know why we would want to complicate things with trying to figure out.
Does the current withholding order collect something towards the arrearages from each pay period?
It might be something minimal, maybe $25. But here we are a year later, and Mr. Fagan has done nothing on his own. He knows he has this arrearage. He had this obligation. There was a problem. Initially, the friend of the court sent the withholding order to the wrong employer. So Mr. Fagan knew he had an obligation, but he did nothing on his own to directly go and pay. So there was a substantial arrearage initially, and then there were some arrearages or shortfalls during the springtime for whatever reason. So it's a rather significant arrearage, and he's done nothing on his own.
How much is it?
Alexis, how much is it?
At the last time I checked, it was I think $2,600. He was ordered to pay in November and I didn't receive anything until February, after it was close to March. And then again, when he stopped working during the pandemic, I didn't receive anything either. So there's been a few times that child support's not been received.
So how much, Mr. Fagan, is currently being withheld for each pay period?
I receive $131.61 a week. It's every 7 days.
It's $519 a month, Judge.
Yeah.
$519 a month is what he's charging right now.
Correct.
And what she's getting is $131.61 per week.
Yes. So it doesn't
Well,
sound
let me
like
do the
she's
math.
getting much, if any, she might be getting $25 a month on the arrearage.
Well, I'm sure they're withholding the maximum, but hold on a minute.
I think she's getting $50 a month on the arrearage.
$51.31 a month. At that rate, it is going to take a while to pay off that arrearage. How much did you say it was?
I think around
26
100 the last time I checked.
I didn't hear that. Say it again.
I'm sorry, around 100, I believe the last time I checked.
Again, you broke up just as you said the number.
Around 2,600.
Okay, that came through. Thank you. Yeah, assuming he has no further periods of unemployment, it's going to take better than 4 years at that rate to pay off that arrearage. I realize it's complicated to address. Well, let me think for a minute. When there is an arrearage, isn't there automatically, doesn't the refund get captured to go towards an arrearage?
I believe if the friend of the court, if the timing is right, that they will do, they'll do a tax intercept, but if he's paying on the arrearage, I don't know if they do. If the arrearage is greater than 3 months, support, they're supposed to, but then it's all a matter of timing. If they get the garnishments prepared and if they hit the IRS or at the right time, then yeah, they'll grab his refund. And then it will sit for 6 months during the objection period. And then it will be June or July before she sees it and he won't have it.
Yes, you have to file something, and now is about the time that it should be filed. But But yes, you file something with the front of the court, and then they will do whatever paperwork they need to address that, and they will garnish the tax return.
Which, of course, Mr. Fagan can address that. If he adjusts his withholding so he's not getting a refund, there might not be anything for her to get.
What?
I mean, we don't know for sure that he's gonna get a refund. So if he adjusts his withholding, I mean, who knows?
And what do you want it to say? Do you want him or her to claim Millie this year? Will that fix it?
Well,
I had the kids majority of this year, so I should be able to claim both of them this year.
right, so, the exemption was not. What page is that on? Here we go. I mean, ordinarily, if you didn't have an arrearage, I would agree with your provisions. So we can either say that she claims both children and will give him a credit on the benefit that she receives until such time as his arrearage is paid in full. And then after that, he can claim Corbin.
And so her accountant is gonna calculate the difference. The accountant's gonna calculate it if she doesn't have the exemption, and if she does, and then report to us the difference.
Well, I think claiming one child, it's whatever the dependent credit is. It's however many children she can claim, and I don't know, I'm not an accountant, what the amount is. So if it's $1,200, I'm sorry, I don't know if it's $1,200, $2,000, whatever that credit is, then she gives him a direct credit for taxes. But I agree, for 2020, she's had the kids in her sole custody for more than 6 months. I mean, by rights, she should claim them both anyway.
Why doesn't Jake just claim Corbin and I will claim Millie? This is getting very complicated. This is just too much. So Jake can claim Corbin, I will claim Millie. But for this year, I think that I should be able to claim both the children since I did have them without any help from him.
Okay, so
I think that's very reasonable. So for tax year 2020, mom gets both. In the future, each parent gets one child.
Thank you.
Okay, let's see what's next.
the bankruptcy provision.
Is that, that's, I mean, the only payment issue involved here is child support, and that's not subject to bankruptcy, so does it really matter?
They're joint debts, Judge. There's the joint phone bill that they're each supposed to pay half. There's a signature loan. I mean, that's not a standard provision unless it's mutually agreed
But
upon,
this-
and it wasn't.
I don't
But
have
it-
any problem removing. I don't care. I don't have any
Doesn't it
problem.
work to both parties' advantage, though? Okay, yeah, the mutual release and settlement language, et cetera. enforcement, et cetera, that needs to come out. I would not normally order anything like that. That's a matter that parties often agree on, but that's not something I would ever order. I addressed attorney fees at the time a request is made.
So there's also the complete, there's those 3 provisions there on page 7, the mutual release, the
Right,
complete settlement, and the enforcement.
I was speaking to all of that. Your paragraph F,
Okay,
I agree. I didn't order any of that. That needs to come out. G does need to be in it. And is that everything?
yes, Judge, I believe you've addressed everything.
Okay, very good. I will watch for a revised judgment of divorce, assuming it meets with everybody's agreement. I assume you can approve as to form, Ms. Fleming?
Do we need to, and do we have, there's, I guess maybe if it's silent on these, I have notes here that other things that weren't addressed, vehicles, bank accounts, retirement, and COBRA. Do we need to address any of those, or are you satisfied with how that is all set?
Was there a personal property? The real motor vehicles? You have the vehicles on top of page 5, personal property. That's
I'm
in
just
there.
asking, you're satisfied with all of that? Because I don't believe those were addressed in the opinion.
Yeah, that's fine. Yeah.
All right. Okay, perfect.
All right, thank you. I'll watch for that revised judgment. Have a
Okay.
good day, everyone.
Thank you, Judge, too. Alexis, I'll call you.